A single, solitary falsehood recorded on a federal document, even one committed out of ignorance rather than malice, is sufficient to trigger a federal prosecution sequence that ends with a 10-year sentence in a federal penitentiary and a $250,000 financial penalty. Today, we are deconstructing 9 catastrophic errors committed during the purchasing process that are actively costing first-time buyers their freedom. By the conclusion of this briefing, you will possess the tactical knowledge required to navigate the acquisition of your first firearm legally, bypassing the bureaucratic traps that are currently sending law-abiding citizens to court. Understand the urgency of this timeline. Within this calendar year alone, federal prosecutors have leveled felony charges against dozens of first-time purchasers for procedural errors committed during the transaction. We are not discussing career criminals. We are talking about individuals who believed they were compliant with the rules, some of whom are now serving prison sentences. Others have been stripped of their right to own firearms in perpetuity. This is happening in real time. If you have any intention of acquiring a firearm, you must internalize these failure points before you ever step foot into a dealership. Mistake number 1. The perjury trap on ATF Form. You are standing at the counter, filling out the federal background check affidavit. You may not realize you are lying, but the federal government does not distinguish between confusion and deceit. We are looking specifically at question C. This inquiry asks if you are an unlawful user of marijuana or any controlled substance. Here is the scenario that entraps thousands. You smoked marijuana last month in a state where it has been legalized for recreational or medical use. Consequently, you mark no on the form because you operate under the assumption that state legalization equates to lawful status. That single check mark instantly constitutes a federal felony. Under USC. A. Any false statement recorded on form is a crime, regardless of whether you fully comprehended the nuance of the question. The penalty is severe, up to 10 years in federal prison and a fine of $250,000. Federal prosecutors are indifferent to your intent. They do not care if it was an honest mistake, and they certainly do not care if you are a first-time buyer. In DUI, the Bureau of Alcohol, Tobacco, Firearms, and Explosives referred hundreds of these specific cases for prosecution, and federal judges are handing down actual prison sentences. This is not a warning. It is a felony conviction that liquidates your future. Your defensive protocol is clear. First, you must accept that marijuana remains federally illegal, regardless of your state's statutes. If you have utilized this substance recently, you cannot legally purchase a firearm. Period. Second, you must read every question on form twice before applying. Ink to paper. Third, if ambiguity exists, demand that the dealer explain the question before you answer. Fourth, never allow a third party to dictate your responses. The answers must reflect your actual status. And fifth, if you have a history of drug use, criminal charges, or mental health commitments, consult a firearms attorney before you attempt the purchase. Lying on the form is not the only vector for federal custody. The second mistake involves the flow of capital. Mistake number 2, the straw purchase. This is defined as purchasing a firearm for another individual using their funds. Consider the scenario. Your associate cannot pass a background check, so he hands you cash and requests that you acquire the weapon on his behalf. Or perhaps a family member, like an uncle, provides you with funds to purchase a gun as a surprise gift for a cousin, but the transaction is in your name. Both scenarios are federal felonies classified as straw purchases. Under USC, A, and STAU, you are falsifying the identity of the actual buyer on form. It is irrelevant if the end recipient is legally permitted to own a gun. It is irrelevant if your motivation is to assist your family. The moment you utilize another person's capital to acquire a firearm intended for them, you have committed a federal crime. The penalties have escalated. Straw purchases now carry 10 to 15 years in federal prison and up to $250,000 in fines. If that firearm is subsequently utilized in a crime, your exposure increases to 25 years. The ATF actively traces these weapons back to the original purchaser, you. In each try, federal courts sentenced multiple first-time offenders to multi-year prison terms for this exact violation. The legal pathway is rigid. If you intend to gift a firearm, you must utilize your own funds exclusively, and the recipient must be legally eligible. You cannot accept reimbursement. If anyone asks you to buy a gun for them, the answer is an absolute no. Direct them to the counter to handle their own transaction. If you are buying for yourself but someone offers financial assistance, decline it. The only exception is a bona fide gift paid for entirely by you with zero expectation of repayment. Document this transaction. Retain receipts proving the source of funds. Never, under any circumstances, accept money from a third party to purchase a firearm they will receive. Mistake number 3 occurs at the point of sale, and most first-time buyers are completely oblivious to its illegality. This is attempting to purchase a firearm while subject to a restraining order or protection order. You may be navigating a divorce or a custody dispute. Your former partner files a restraining order against you. You may believe it is unjustified or temporary, and feeling vulnerable, you decide to purchase a weapon for self-protection. You enter the store, complete the form, and the background check results in a denial. The danger lies in the paperwork. Some buyers fail to disclose the order, believing it does not count because it is not a criminal conviction. Under federal law, specifically U.S.C. G. If you are subject to a qualifying restraining order, you are prohibited from purchasing or possessing firearms. Lying about this status on the form is a separate felony. You face up to 10 years in federal prison for the false statement, plus additional charges for illegal possession if you already own firearms. The courts are indifferent to your opinion on the fairness of the order. If it was issued after a hearing where you had notice and the opportunity to participate, and it restrains you from harassing an intimate partner or child, you are a prohibited person. Your action plan must be precise. First, check immediately if any orders have been filed against you during domestic disputes. Second, realize that even temporary orders can trigger this prohibition. Third, if an order is issued, surrender existing firearms within the state-mandated time frame, typically 24 to 48 hours. Fourth, do not attempt to purchase while the order is active. Fifth, consult a specialist attorney regarding restoration. And sixth, obtain written documentation from the court proving the order is lifted before you ever attempt to buy again. Mistake number 4 involves your history, specifically failing to disclose past criminal charges or convictions because you believe they are obsolete. Perhaps you were arrested 15 years ago for a misdemeanor. The case was dismissed, or you completed probation, and you believe the matter is closed. On Form Hours, Question B asks if you have ever been convicted of a crime punishable by more than 1 year in prison. You mark no because you believe misdemeanors do not qualify. Here is the reality. Federal law assesses the maximum possible sentence for the crime, not the sentence you actually served. If your misdemeanor carried a potential sentence exceeding 1 year, even if you only received probation, you may be prohibited. Furthermore, if you were convicted of a misdemeanor crime of domestic violence, you are federally prohibited regardless of the sentence length. Falsifying this information is a federal felony carrying 10 years in prison. The ATF cross-references your answers with criminal databases, and mismatches lead to prosecution. Multiple first-time buyers face charges for failing to disclose old convictions they deemed irrelevant. To handle this, obtain your complete criminal record from the FBI and your state before you attempt a purchase. Research the maximum possible sentence for every past charge. If you have any domestic violence convictions, assume you are prohibited. If you are unsure, consult an attorney before touching form. Never guess. If you were convicted but had the conviction expunged, verify that your rights were specifically restored, as federal law may still view it as a conviction. Mistake. Number 5 occurs in real time at the gun counter, and it is shockingly easy to commit. This involves purchasing a handgun across state lines without routing the transaction through a licensed dealer in your home jurisdiction. The scenario is deceptive. You reside in California, but you are visiting family in Nevada. You enter a Nevada retailer and identify a handgun at a price point that is irresistible. You rationalize, I will purchase it here and transport it home personally. The dealer processes the background check, you take custody, and you have just committed a federal felony. Under USC, A, and B, you are strictly prohibited from purchasing a handgun from a dealer in a state where you do not maintain residency. While long guns operate under different regulations, handguns must be transferred through a dealer in your home state, even if the laws of both states theoretically permit the purchase. Federal law prohibits the direct transfer. Violating interstate transfer statutes carries a penalty of up to 5 years in federal prison. The ATF tracks these acquisitions. When you attempt to register that firearm in your home state, or if it is ever subjected to a trace, you will face charges. This is not a gray area. It is explicitly illegal, and federal prosecutors pursue these violations aggressively. The only legal mechanism is rigid. If you wish to acquire a handgun in another state, the out-of-state dealer must ship the asset to a licensed FFL in your home state. You then complete the background check and take possession from your local dealer. While this incurs additional cost and time, it is the singular legal method. Furthermore, never attempt a private sale across state lines. All interstate transfers must involve FFLs. If you are relocating to a new state, research that jurisdiction's registration protocols immediately. Some states mandate registration within days of establishing residency, and failure to comply creates criminal exposure. Interstate purchases are a federal trap, but what I am about to detail next could cost you your freedom before you even exit the parking lot. Mistake number 6, buying a firearm legally, then immediately transferring it to an individual who cannot legally own firearms. You have just acquired your first weapon. Your roommate expresses interest in testing it at the range. You hand it to him, unaware that he carries a felony conviction from a decade ago. Or perhaps your brother-in-law requests to borrow it for home defense, and you are ignorant of the restraining order filed against him. The moment you transfer possession of that firearm to a prohibited person, even temporarily, even for 5 minutes, you have committed a federal felony under USC. D. Ignorance of their status is not a shield. Federal law holds you strictly liable for ensuring anyone you transfer a weapon to is legally eligible. This violation carries up to 10 years in federal prison. If that individual utilizes the gun in a crime, you are facing additional charges and massive civil liability. The ATF will trace the serial number back to you as the purchaser of record, and you will be the primary target of the investigation. "I didn't know" will not prevent your incarceration. Your defensive posture must be absolute. First, never permit anyone to handle, borrow, or take possession of your firearm unless you are mathematically certain of their legal status. Second, if someone asks to borrow your weapon, the answer is no. Direct them to a rental facility or a dealership. Third, if you are at a range, direct supervision is generally acceptable, but they must still be eligible. Fourth, never leave your weapon accessible in your home. Use a safe. Fifth, if you conduct a private sale, utilize a licensed dealer to run a background check to insulate yourself from liability. Mistake number 7 involves the purchase itself and an intent that you might believe is legal. This is purchasing a firearm with the intent to immediately modify it in ways that violate federal law. You buy a pistol and have already researched the addition of a forward grip to enhance tactical control. Or you purchase an AR with the plan to install a bump stock or auto-sear you located online. Certain modifications transmute a legal firearm into illegal contraband under the National Firearms Act. Adding a vertical foregrip to a pistol can reclassify it as an any other weapon, AOW, requiring ATF registration and a tax stamp. Installing a bump stock is federally illicit as of D, and converting any semi-automatic to full auto without licensing is a 10-year federal felony. If you purchase the weapon with the intent to execute these modifications, you are committing a crime the moment the transaction closes. Illegal modifications carry 10 years in federal prison and a $250,000 fine. The ATF monitors online forums, social media, and component purchases. If they discover evidence that you planned these illegal modifications prior to purchase, they will charge you with conspiracy. Multiple first-time owners are currently serving time for modifications they assumed were permissible. To stay legal, research federal and state laws before altering any component. Understand that pistol braces, foregrips, suppressors, and short-barreled configurations are regulated under the NFA. Never purchase parts that convert a semi-automatic to full automatic. If you desire an NFA item, file form or form, pay the tax, and wait for approval before making the modification. Exercise extreme caution in online communities. The ATF is watching. Mistake number 8 happens within the first 60 seconds of ownership. This is walking out of the gun store immediately after purchase, in a state that mandates waiting periods or instant registration. You pass the federal check, transact the funds, and attempt to exit. The dealer halts you, citing a 10-day waiting period. Or you reside in a jurisdiction like California, Hawaii, or Illinois that requires registration within a specific window, and you ignore it, deeming it optional. Under state law, violating waiting periods or failing to register can result in criminal charges, confiscation, and the permanent loss of gun rights in that state. California charges illegal possession as a misdemeanor, with jail time and fines. Hawaii mandates registration within 5 days. Failure is a crime. These convictions can trigger federal prohibitions, meaning a state-level administrative error costs you your gun rights nationwide. You must research your state's specific requirements for waiting periods and registration before you buy. Understand that passing the NICS check does not override state waiting periods. Complete registration within the mandated time frame. Keep every scrap of documentation. Never assume reciprocity of possession. Crossing state lines into New York or New Jersey can turn your legal firearm into a felony instantly. Mistake number 9 is the most dangerous because it occurs in the privacy of your home. This is storing your newly purchased firearm in a way that allows prohibited persons or children to access it. You place your weapon in a nightstand for readiness. However, your teenage son has a friend with a juvenile adjudication, or your spouse has a buried misdemeanor domestic violence conviction. If that individual accesses your firearm, you have facilitated illegal possession under USC-D. Even worse, if a child accesses an unsecured firearm and injury occurs, you face criminal charges in the 27 states with child access prevention laws. Criminal liability for improper storage can include felony charges and prison time up to 5 years, alongside massive civil liability. If a prohibited person accesses your gun and commits a crime, you face federal charges for facilitation, 10 years in prison. Your homeowner's insurance will not cover criminal penalties, and the civil lawsuits will bankrupt you. Invest in a quality safe immediately. This is not optional. Never leave firearms unsecured. Use trigger locks as a secondary measure. Store ammunition separately. If a household member is prohibited, you must ensure they have absolutely no access to your armory. Let us recap the 9 gun purchasing mistakes that could land you in federal prison. Mistake 1. Lying on form, 10 years in prison. Mistake 2. Straw purchase, 15 years in prison. Mistake 3. Purchasing under a restraining order, 10 years in prison. Mistake 4. Concealing past criminal charges, 10 years in prison. Mistake 5. Interstate handgun purchase, 5 years in prison. Mistake 6. Transfer to a prohibited person, 10 years in prison. Mistake 7. Intent to modify illegally, 10 years in prison. Mistake 8. Ignoring state waiting periods, state felony charges. Mistake 9. Improper storage allowing access, criminal and civil ruin. Any one of these errors can cost you $250,000, years of your life, and your Second Amendment rights forever. These are not scare tactics. These are the operational realities destroying lives right now. First-time buyers are being incarcerated because they remained ignorant of these rules. Do not let confusion cost you your freedom.